Let's go on the record on cause number, going slowly today, DC 19359, Harris versus SB Premium. Counsel, make your appearances.
Good morning, Your Honor. Matthew Brining on behalf of plaintiffs. I'm here with my co-counsel, Ms. Natalie Arledge.
Your Honor, Robert Bogdanovich for defendant Triton Distribution.
Your Honor, Andrea Turner for defendants SB Premium, LLC, Tiffany Grisham, and Larry Gresham.
Let's proceed.
Thank you, Your Honor. So the plaintiffs are here requesting some new discovery. Now, the purpose of discovery is to narrow the issues in dispute, avoid surprise at trial, and facilitate resolution. And that's really what this request for additional discovery is for. To be clear, we are not seeking to start discovery from scratch. That was an allegation in defendant's opposition. So far, the evidence has been good for plaintiffs. We have no reason, no need, no want to restart this case from scratch. What we are seeking is, again, targeted discovery to narrow issues in dispute, avoid surprise at trial, and potentially push this case towards informal settlement. Now, under Texas Rule of Civil Procedure 190.5, the court may modify a discovery control plan at any time and must do so when the interests of justice requires. Now, we are still 8 months away from trial. And that's assuming that we even go out at the end of March of 2022. It is not in the interest of justice to require plaintiffs and only plaintiffs to sit on their hands for the next 8 months. Now, recall that defendants have already been granted additional fact and expert discovery. So, it's also, I think, important to remember that we are here at the forefront of the science and litigation with regard to vaping and the harms. There's a youth vaping epidemic. Other courts, lawmakers, and industry leaders are going to be looking at what happens here. So we owe it to ourselves and the community to put the best case forward, and that's for both plaintiffs and defendants. We want the strongest case on both sides, and we want a decision to be reached on the merits based on a full record. So given that, plaintiffs are, again, respectfully requesting the discovery control plan be modified pursuant to the court's authority to do so under Rule 190.5 in the interest of justice to allow, again, targeted discovery to narrow issues and avoid surprise at trial. Now, kind of a second part of that, or not a second part, a second analysis would be under the court's authority pursuant Rule 190.5 Section B, which I read as separate and distinct from the previous analysis. And 190.5B requires further discovery to be allowed if there's been a material change and it's 3 months prior to trial. Now, again, our trial is end of March 2022. We're well beyond the 3-month period.
What discovery do you need?
So specifically, we would like discovery relating to, are you asking topics or types?
Yes, both.
Okay. So I think some written discovery, some, and that would be written interrogatories, request for admissions, request for production, some deposition time, and potentially 1, maybe 2 experts, just to really solidify this, present the best case possible. And the topics that I think would be of most import here would be relating to the warnings that were provided, any investigation regarding product safety, and I guess any claims regarding product safety. As Your Honor may recall, at the motion or at the hearing on the request for leave to amend, the defendants claimed that the enumeration of propylene glycol and vegetable glycerin and complaints completely changed the basis of the case. Now, I think that is an overstatement, and I can elaborate more on that. But because they have made that assertion on the record, I think it makes sense that plaintiffs need to investigate that claim now. We need to know, okay, with the propylene glycol vegetable glycerin, do they still contend that their e-liquid is safe? Do they still contend that they warned about those dangers? I think the answer is no, but that needs to be resolved now rather than at trial.
And that new claim came from the defendants or from y'all?
So let me back up. So propylene glycol and vegetable glycerin, those are two of the main components of defendant's e-liquid. Those have been known to, when heated, release significant amounts of carcinogens. And again, this is a wrongful death based on a mouth cancer case. Those two ingredients were enumerated in the amended complaint. And the claim by defendants was that by enumerating those two ingredients in the complaint, we've completely changed the basis of the case. I think the assertion was they had no idea that propylene glycol and vegetable glycerin were at issue here, which again, I think that's an overstatement. Their defendant's expert toxicologist, Dr. Maddle, she's written a paper. Prior to her deposition, she wrote a paper about propylene glycol, vegetable glycerin, their use in e-cigarettes, and the carcinogens that are related to those ingredients. So again, I think that's an overstatement for a number of reasons. But they have essentially made the claim, look, we didn't know what was going on. We didn't know that those two ingredients were a part of this claim. Therefore, that completely changes the basis of the case. And so my position is, all right, tell us how that changes the basis of the case. Is your e-liquid still safe? Do you still contend that you warned about those risks? And I think that's going to be important to handle now rather than a trial.
I guess my question is, and I agree that I'm going to allow you to have some additional discovery. I'm just kind of trying to figure this out. So you guys changed your petition. They're claiming that changes everything, but that doesn't necessarily make that so. It was y'all's decision to change the petition. I guess I'm just trying to figure out why you didn't just file this originally with those claims. Was that something that you discovered through the course of this discovery, or you just changed your theory because you talked to a new expert, or why did you change your allegations?
Understood. Thank you, Your Honor. So really the impetus for the first amended complaint, this was around the time of the summary judgment hearing. And really the pleading was amended so we could remove one of the causes of action that we had. And that was really the main purpose of that. The enumeration of propylene glycol and vegetable glycerin were in there essentially to conform to proof. That's what the evidence has shown as we've gone through discovery, that propylene glycol and vegetable glycerin are important in the creation of the carcinogens that come out of the e-liquid vapor.
Okay, so go ahead and make a proposal on exactly what, and let me just say to your opposing counsel, which is, I'm going to allow more discovery. This case is complicated. I understand why there needs to be more discovery. I typically on products cases will allow discovery at, with some limited discovery up until trial. I don't want unlimited discovery. I don't think that's fair to the defendants. And so what exactly is the scope? How many fact witnesses do you still need to take before trial? Depositions?
Depositions for fact witnesses, that may be somewhat based on what responses we get in written discovery. I suspect 4 or 5 would do the trick for fact witnesses.
Haven't they already answered written discovery?
They have answered some written discovery, yes, Your Honor.
Okay.
And we would like some additional written discovery, some again, targeted discovery aimed at a couple of the issues.
But you've surely sent requests of disclosures already, right?
We have, Your Honor.
And they've identified persons with knowledge of relevant facts?
Yes, Your Honor, but I think we would like a more, again, I think we may need to wait and see what their responses are to our upcoming written discovery.
Okay. All right, 4 to 5 fact witness depositions, expert witnesses.
Yes, Your Honor.
Said you needed 2.
I think 2 should do the trick, Your Honor.
And then you said you needed another, what else, what other written discovery did you need to send?
Would you like a number?
Just what is it?
So we would like some written interrogatories, requests for admissions, and potentially a request for production of documents.
Okay, how many interrogatories?
I think 30 should do the trick.
Requests for admissions?
Probably the same, 30.
And requests for production?
30 again.
And is this 30 to each defendant or just to one particular defendant? Or is it, how many are left right now? How many defendants are left?
So I think there are 2 main defendants here. They seem to be represented by the 2. It's now one law firm, but there are 2 sides of that law firm representing them. I think 30 to each defendant would be appropriate. That being said, I don't intend to, if we don't need them, we will not use them. I don't intend to use them in a way that would be burdensome in any way.
Let me hear from the defendants on their position on this.
Yes, Your Honor. Well, I understand the court's position in allowing some additional discovery. I think identifying the scope of what's going to potentially happen here is important because if you'll recall, Your Honor, we moved to strike their petition in January because after 2 years, they added that it was not just the flavorings in these e-liquids that caused Mr. Harris's mouth cancer. It was now also propylene glycol and vegetable glycerin. Now, besides the fact it was untimely, it was after summary judgment briefing, discovery had closed, everyone had designated expert witnesses related to what they had alleged caused the cancer. Depositions were taken, and those 2 ingredients were never discussed in terms of how did they cause the cancer allegedly? What is the defense against it, et cetera? And it's my understanding, Your Honor, in that letting them amend their petition instead of striking it, that's why, Your Honor, also let us and the defendants alone engage in specific discovery if we so chose, amend our pleadings if we so chose to address those 2 new ingredients that they had alleged, because they hadn't until that point. Discovery's closed. We've already retained experts, deposed them, et cetera. We've not yet elected to do so. So now here, when they were originally arguing, it really didn't change the case. That's what they had mentioned at the hearing. And now they're saying that it's something they've developed through discovery. It's not been. And here what's going to happen is they are going to have the opportunity to designate new experts, basically change the theory and basis of their lawsuit at this point.
I didn't hear them to say that they were going to, are you designating new experts? I thought you just wanted to depose experts. I didn't understand that. Was that right?
So potentially would like to designate a new expert, 1 or 2 new experts. But again, I think that depends on the discovery responses we get. I would like to reserve that right. If we don't need it, we're not going to designate any experts we don't need to designate. But if any new information comes out of this discovery, we'd just like to reserve that right to designate 1 or 2 new experts.
Okay.
Your Honor, therein lies the problem, which we had argued at the motion to strike hearing, which is after 2+ years, after everyone, plaintiffs and defendants have designated experts based on the claims that were disclosed in discovery, were put in the pleadings, we're now changing and addressing 2 brand new things. It's akin to this case being about the brakes being faulty in a vehicle. And then at the 11th hour, it's not just the brakes, it's also the transmission. I don't know what other experts may or may not be necessary. None of them on our side or theirs have talked about propylene glycol or vegetable glycerin and the manner in which they may have caused or not caused this cancer. It's been the flavorings. That was it since day 1 when they filed in January of 19. And now what we're looking at is, as counsel just said, potentially having them designate additional experts. They get to reopen this entire case. I don't know how many would possibly be necessary. And I believe that's why, Your Honor, when we argued the motion to strike, gave us the unilateral opportunity, if we chose, to address these 2 new ingredients by use of amended pleadings, discovery, experts, et cetera. We haven't done that. But now to have plaintiffs essentially have the opportunity to redo their case, despite the fact trial has been postponed. We're unending 2 years of expensive litigation. This has never been an issue until after the summary judgment brief.
I think Mr. Bogdanovich makes a compelling point here. I mean, you guys had experts and you had a theory, and now you've changed it. I would have assumed that when you changed the theory, you would have changed your experts. I'm kind of confused on what's going on here.
Yes, Your Honor, thank you. So this is not a theory change at all. The theory has been and has always been that when heated, defendant's e-liquid releases carcinogens when heated to normal vaping temperature. Now, this is not the case where it's an automobile case and we're claiming that the brakes failed and then we changed. This is a case where Coca-Cola is causing an issue, and we bring a claim against Coca-Cola saying your Coke is causing some harm. And then through discovery, we learned that it's not only the fructose, it's some other ingredient that's causing that additional harm. Now, to the idea that the experts have already been deposed and this is back, this is redoing all of that, that is not accurate. All of the treaters testified in favor of causation, not based on propylene glycol or vegetable glycerin or flavorants or anything specific as to that. They did it based on, in part, the literature that says when e-cigarette liquid is heated, it releases carcinogens. Dr. Model, again, defendant's expert toxicologist, did not testify that the flavorants were safe, but I'm reserving judgment for propylene glycol. She testified e-cigarettes do not cause cancer. They do not increase risk of cancer. And that was based on, again, not looking at a specific ingredient. It's looking at e-liquid in general. So this is not changing any theories. This is not adding anything new that hasn't been there. The claim is, and always has been, defendant's e-liquid, when heated, releases carcinogens.
Your Honor, if I may.
Okay. Yes.
Their pleadings and their responses to written discovery, et cetera, were very specific since day one. They alleged that the flavoring in these two e-liquids caused Mr. Harris's mouth cancer. That's what we've all proceeded on since January of 2019. And so the addition of propylene glycol and vegetable glycerin, after all of this has been done, after MSJ briefing, et cetera, it does change the dynamics. Again, this is why I believe the court ordered the discovery the way that the court did when we had the motion to strike hearing. It's two different ingredients. And you can't just say Coke caused the cancer or caused some harm. They do have to allege what caused the harm. They had the flavorings. They're changing it now. They're adding two different things that no experts have opined about, touched upon in any significant fashion in respect to whether or not it caused or did not cause cancer. And so now, again, by reopening this discovery, their proposed scheduling order is to give them that opportunity on their side to add experts to address these two ingredients now, which have never been addressed. And again, I don't even know if any of my experts would be capable of addressing that, because we hired them specifically based on allegations that have been standing for 2+ years. This does change the nature of the case. And again, I think that's why we have the opportunity to amend pleadings, discovery, et cetera, if we choose, and not plaintiffs, because they're getting a second crack at the apple now. They're talking about Rule 195B, matters that have changed materially after discovery cutoff. They're the ones who changed it after discovery cutoff. They can't hide behind that rule and then get to enjoy another year of discovery, expense, experts, et cetera, when they've litigated a case based on flavorings since day one.
Your Honor, if I may address one point really quickly. When I say that we're going to potentially add another expert, I'm not talking about another expert to testify about causation as to propylene glycol versus vegetable glycerin versus the flavorants. Our expert on that is Dr. Onkeko. That's who it's going to be. He authored his report that e-cigarettes can cause and do increase the risk of cancer based on, he enumerates 4 different types of evidence that we have on that. We're already past summary judgment on that. I have no interest in adding another expert to testify as to the propylene glycol versus vegetable glycerin. That, in my mind, has already been established. And just to remind the court, at the last hearing, when defendants, we'll strike that, never mind, I'll finish with that.
So who are the fact witnesses you need to depose?
It would be the individuals who created the warnings and the individuals who investigated product safety. And that may be one person, Your Honor.
Okay, I don't think that's unreasonable. So I don't have any problem with that. And the expert is, what would be the expert on?
The expert would be on warnings.
On warnings, okay. That's been an allegation since the beginning. Why didn't you designate someone earlier?
As to warnings, Your Honor, I think if I were to, as I continue to practice, I learn something new every day. If I were to try this case a number of times in the future, I may designate a warnings expert earlier. Here, I think the fact that defendants appear to be raising this issue of, is it the propylene glycol, is it the vegetable glycerin? I think that makes it more likely that we need an expert to come in and explain nuances there.
Because those are their new allegations, Your Honor. That's the whole problem here is they're going to send discovery out about what? Warnings that relate to, most likely, propylene glycol and vegetable glycerin. So then we're put in a position where if there is or is not a warning about it, should there have been a warning? Do they cause cancer, et cetera? That's never been a part of this case. We're going back to them having the opportunity to relitigate, designate new experts, et cetera, on those two issues. They specifically.
So what I'm going to do here, I'm going to allow 10 more interrogatories, 10 more to each defendant group, 10 requests for production, 10 requests for admissions. I'm going to allow two depositions of fact witnesses only on the issue of warnings. And I'm going to hold off ruling on the expert issue until after the fact witnesses are taken to see if there's anything new about that. So go ahead and prepare an order for me on this, and we will go from there. Thank you, guys. And make sure when you prepare the order that it says the order was on August 2nd, heard on August 2nd, 2021, sorry, and that you email Rhonda a copy of the order as well as e-file it and share it with opposing counsel. Thank you, guys.
Thank you, Your Honor.
Thank you, Your Honor.
Thanks, guys.
Thank you, Your Honor.
Thank you. Okay, so we have 11 o'clock hearing. Is everyone here on the 11 o'clock hearing?
Your Honor, I believe that's Mr. Tittle and myself, and we are here.
Yeah, it's a little bit, that's Haltom versus Triplet, right?
Yes, Your Honor.
Let's go on the record on Haltom versus Triplet, cause number DC 181418. Counsel, make your appearances.
Good morning, Your Honor. Brandon Tittle on behalf of Jeremy Haltom.
Reagan Harrod here on behalf of Don Triplet.
Okay, I've read all of this. I will tell you how I generally handle this issue, and that is you guys have requested a stay because you filed a mandamus. I usually let the Court of Appeals just make that decision. I don't usually get involved in that. So if the Court of Appeals feels like they want to stay me, they can. But if they don't need to stay me, that's fine too. So, but is there any reason I should treat this any differently than what I usually do?
No, Your Honor. Sometimes, though, procedurally, when you request to stay with the appellate courts, they want to know that you've asked the state court judge who ruled on it for a stay first. Sometimes they like you to go through the original judge before you ask the for permission for a stay. So we did it just out of abundance of caution before we tried to take it up to the appellate court.
Okay. Unless you guys want to agree on this, I'm inclined to deny it.
Your Honor, I mean, obviously we would prefer, you stayed if you could. We do feel like there are circumstances here that would lead to this being an exigent circumstance that, we prefer some type of ruling on this since they're going to try to sell the home as quick as they can, which would then, defeat the purpose of our mandamus. But obviously you're aware of the facts and circumstances of the case, so we'll defer to your judgment.
Now, I will say I looked at this very carefully. I actually had an intern write a memo about it. I didn't confer at all with the intern, and they came up with the same conclusion I did. So I feel fairly comfortable with my decision unless the Court of Appeals changes the law. I don't really get that option. It's usually Court of Appeals gets that option. So I'll let the Court of Appeals make the decision on the stay unless the parties agree. Mr.
Your Honor,
Hare,
we're not in agreement. If the Court of Appeals wants to stay it, I mean, obviously, that's their prerogative and we'll abide by it, but I think that it's appropriate for them to take up the issue.
go ahead and submit an order to that effect and make sure that it says that that this was heard on August 2nd, 2021. E-file that with the clerk's office and then email Rhonda and let her know, and make sure you share a copy of the order with Mr. Tittle, okay?
Okay, Your Honor, will do.
Thank you, guys.
Thank you, Your Honor.
I think that's our last hearing for the morning. Okay, it's been a busy morning. Okay, that's it for